Cold Reckoning presents the man who sued $1 billion company and won. He had $47 in his bank account. No lawyer, no connections, no one in his corner. On the other side of the courtroom sat a team of attorneys in $3,000 suits, representing one of the most powerful insurance companies in the United States. Everyone told him to give up. His own family told him to let it go. He didn't. What happened next didn't just change his life. It sent shockwaves through the legal system and exposed a tactic that insurance companies had been quietly using against ordinary people for decades. This is the story of Marcus Webb, and this is Cold Reckoning. It started on a Tuesday morning in March. Marcus was driving to his second job, because one job was never enough, when a distracted driver ran a red light and hit him at 45 miles per hour. The impact was violent. His car spun twice. His shoulder was shattered. 3 ribs broken. The ambulance came. The hospital came. The bills came too. $84,000 in medical bills. 6 weeks unable to work, and a shoulder that would never move the same way again. But Marcus had insurance. He'd been paying his premiums for 11 years without a single claim. Never late, never missed a payment. He wasn't worried. He thought the system would protect him. He was wrong. 2 weeks after the accident, a letter arrived. Marcus sat at his kitchen table and opened it. The insurance company was offering him $4,200. $4,200 for $84,000 in bills, for 6 weeks of lost income, for a shoulder that would require surgery and years of physical therapy. He read the letter 3 times. He thought it was a mistake. It wasn't. When he called, the representative was calm, almost bored. She told him the offer was based on their internal assessment. She told him he had 30 days to accept. And then, almost as an afterthought, she said something that changed everything. She said, "Mr. Webb, I'd encourage you to accept. These cases almost never go anywhere for people in your situation. People in your situation." Marcus hung up the phone. He sat in silence for a long time. Then he opened his laptop. "Now, before we go further, I need to ask you something directly. Have you or someone you know ever been lowballed by an insurance company after an accident? Drop it in the comments right now." Because what Marcus discovered next is something they absolutely do not want you to know. Marcus spent 3 weeks reading legal forums, court filings, consumer protection law. He couldn't afford a lawyer. He'd called 6 of them. Every single one wanted a retainer he didn't have. One of them told him, quote, "The juice isn't worth the squeeze." But Marcus found something, a pattern. Insurance companies have a practice, documented, studied, and quietly notorious in legal circles, called lowball and delay. They offer a fraction of what a claim is worth immediately after an accident, banking on one thing. They bank on desperation, They know you have bills. They know you're scared. They know most people will take whatever they can get just to make the nightmare stop. And for decades, it worked. But Marcus wasn't desperate anymore. He was something far more dangerous. He was informed. He filed a complaint with the state insurance commissioner. He documented every call, date, time, name of the representative, exact words spoken. He sent a formal demand letter citing 3 specific statutes the company had potentially violated, including bad faith insurance practices, a legal claim that, if proven, can result in damages far beyond the original claim. The company's response came fast, faster than anything before. Suddenly, there was a new representative. Suddenly, the tone changed. Suddenly, they wanted to talk. They revised their offer to $31,000. Declined. He filed in civil court, representing himself. Pro se, the legal term for it. No attorney, just Marcus, his folder of evidence, and 11 years of anger that had finally found a direction. The night before the hearing, Marcus sat alone in his apartment. His hand was shaking as he organized his documents for the 4th time. He wasn't a lawyer. He wasn't educated in law. He was a man who'd worked 2 jobs his entire adult life and still felt like the system was designed to keep him exactly where he was. But he showed up. He walked into that courtroom in the only suit he owned, a navy blue one he'd bought for his mother's funeral 5 years earlier. He sat down across from 3 attorneys. He opened his folder, and he waited. What Marcus did in that courtroom wasn't dramatic. There was no shouting, no Perry Mason moment. He simply presented facts, organized, documented, time-stamped facts. The original offer, the bad faith timeline, the documented phone calls, the statutes. He spoke for 22 minutes. When he finished, the judge looked at the insurance company's legal team and asked one question. Is there anything here that is factually incorrect? There was a long silence. No, Your Honor. The judge ruled in Marcus's favor. Full medical damages, $84,000. Lost wages, pain and suffering. And then the number that made the room go quiet. Because of the documented bad faith practices, the deliberate lowball, the pressure tactics, the delay, the judge added punitive damages. The final judgment, $340,000. For a moment, Marcus didn't move. The attorney closest to him quietly closed his leather folder, stood up, and left without saying a word. Marcus walked out of that courthouse alone. He sat on the steps outside, the same steps where people had been fighting for justice for over 100 years, and he cried. Not because he won, but because he almost didn't try. Here's what this story is really about. It's not about one man beating one company. It's about the fact that the system has tools built into it. Real, legal, powerful tools that most people never use because nobody ever told them they existed. Bad faith insurance laws exist in nearly every state. Insurance commissioners have real power to investigate and penalize companies. And pro se litigation, representing yourself, is a legitimate, documented path that has produced real victories for real people. The gap isn't fairness. The gap is knowledge. Marcus Webb, the fictional composite of hundreds of real cases just like his, represents every person who ever accepted $4,200 because they didn't know they could fight for $340,000. Some of them are watching this video right now. If this story hit different, if it made something in you wake up, share this video with one person who needs to hear it. Not for the views, because someone in your life right now is sitting at a kitchen table with a lowball offer and no idea what to do next. Subscribe to Cold Reckoning. Every week we tell the stories the system hopes you never hear, and we give you the knowledge to fight back. Because the most dangerous person in any courtroom isn't the one with the best lawyer. It's the one who refused to quit. Cold Reckoning. Know the law. Change the outcome.